How you guys doing today? It's Anthony Gangis. Welcome to another episode of Tier Talk. Guys, as I wait for the recap of Day 4 prelim, I thought I could bring Joseph Pangaro on, retired detective lieutenant, and we could talk about some of the evidence collecting in regards to the D4vd case. A lot of stuff that's coming up through the last 3 days of the preliminary. So I thought it'd be interesting just to kind of dive in. Joe is not as familiar with the case as we are, so I'm going to provide some context with each question and then gives Joe a chance to kind of answer things on bias unless I introduce biasness to it. But there is a few things I want to ask. It's related to the questions that were sent my way. And then, guys, hopefully you've been keeping track of my whole entire playlist because I've been doing the breakdowns of the preliminary, and then after each breakdown I do the next day, I post kind of like my inner thoughts. And I'll be back on tonight with Russ again to break down Day 4. See, this is the final day. Hey, Joe, you mind introducing yourself to our audience? And then I'm just going to spitball some questions your way.
Absolutely. I'm happy to be here, Anthony. As always, you have a tremendous program, and the people that are so interested in the work that we do, I think it's amazing. I served for 27 years. I spent most of that time as a criminal investigator. I got promoted up through the ranks. I ended up as a lieutenant. I teach and train. I have a police training business, Pangaro Training, and I write quite a few books and articles all over the place, including The Investigation from Blue 360 Media. I had to throw a little plug in there.
Yes, and it's a great read, guys. If you get a chance, it kind of walks you through an active case. All right, so let me go ahead, provide you the context and with the question. And guys, I'm sure you're familiar with Joe. He's been on my show a couple of times before. So on Day 4, the defense highlighted the burn cage found in Burke's home and testified about the unopened box was. Wait, hold on. This is the wrong set of questions. Oh, here it goes. Chainsaw and the post-homicide purchase trail. So first question, I've been following Lauren Collins' reporting on this case. So Lauren Collins' reporting says prosecutors introduced records showing a shovel purchased April 24th, then multiple chainsaws bought in early May, along with a body bag, heavy-duty laundry bag, an inflatable pool, and later a burn cage and fireproof mat. The defense has already attacked the chainsaws by focusing on the fact that all three were tested for blood, came back negative, and no additional DNA testing or comparison to the cut marks was pursued. So based on your experience, when investigators have a post-homicide purchase trail like that, how much weight do you give to the fact that the chainsaws were found but tested negative for blood? And how significant is it when the handles or other possible touch DNA sources are not further tested in a case like this? So basically, what happened here is, especially with the chainsaws, they came up negative for blood, so there was no further testing because at that point they felt that there just wasn't enough forensic value. And then the defense is actually attacking that, saying, well, why didn't you do further testing, I guess, to maybe weed D4vd out? What's your thoughts on them not sending it for further testing after there wasn't any blood found on the blades or anything to also match the cut patterns on the inflatable pool and possibly, if possible, Celeste Rivas Hernandez, even though she was seriously decomposed?
Sure. When you have any kind of a situation where an implement is used, a knife, a crowbar, a chainsaw, whatever it is, if you're going to consider that it is the murder weapon or an implement of the crime, my opinion, you have to go all the way with it. Just because you didn't find the blood doesn't mean that it wasn't removed in some way. The handle could have touched. There could have been DNA on there. Could have been body oils on there. I would have gone the entire way, but there are considerations that come up. People say, okay, we have no blood, so why are we going to spend the money on further testing? And that you don't want to hear about spending money, but that's a reality. It takes up other resources that we could be looking at other things. When you look at the purchases, though, when you mention that, I find that interesting. I have been involved in many cases where implements were used, removal items, shovels, things like that. And going back and finding those purchases, now you're going to get a video maybe from that sale. You could see what they were wearing. You could see who was with them. You could see what they touched. You might be able to see the parking lot. What vehicle did they have? How did they put it in the car? And why is that important? It all becomes part of a pattern, a fact pattern. And the question starts to come up, well, why'd you buy a shovel? Why'd you buy a big bag? Why did you buy those things? Now, they're common items. People buy them. I have a garden. I got 9 different kinds of shovels out there. I just bought a new one a couple of weeks ago. It's not unusual for me to have those things because I use them in my garden. What is this person doing with these things? And in particular, we had a case where a young lady found out that her boyfriend from 30 years ago got remarried. She showed up from Virginia to New Jersey and attacked the wife at the front door and almost killed her, tied her up, tried to stab her to death. And when we went back, when she didn't know who it was, the wife didn't know who it was, but we went back and we started looking around. We had some things that were left at the scene and we checked back and we found some purchases. And then we started looking at videos of who bought those things. We showed them to the victim. And that's the girl. That's the girl that attacked me. And we could work our way backwards. We then saw the license plate and it gave us our suspect. So that chain is important. So important that, and I hate to do the plugs, but in my book, The Investigation, it was a really brutal double homicide where a guy left point A, came to point B far away and killed 2 people and butchered them. And one of the things we had to show was, how did he get from point A to point B? Looking at that trail, buying gasoline. He bought a gas can along the way. So we had to go search everywhere from New Jersey all the way from Ocean Township all the way up to Newark, every place you could buy a little red gas can. So we found some connections, right? And then we put these things together. It's vitally important to the chain of events.
Does that change when the stuff can now be ordered and delivered? And he looks like he had it ordered and delivered, Amazon Postmates, and then I think he ordered under an alias, but the purchase still came from the same account. But my biggest thing is this, when it comes to this, is if, let's say I didn't notice that there was blood evidence. We did a check. There was no blood evidence. So we decided at this point not to send it for further testing, maybe touch evidence, who knows, touch DNA, whatever it is. Because my biggest concern would be this. If there was no blood evidence on the saw, even if I did test it and it showed that he had handled the saw, how would I be able to say he handled the saw in a manner that would have led to the death or dismemberment of Celeste Rivas Hernandez if there was none of Celeste's blood on the saw?
All right, that's a difficult thing to try and cover. If he used a chainsaw to chop somebody up, you would think that there would be hair fibers, there would be blood, there'd be something on there. But when you think about somebody ordering from Amazon, so let's cover that first. That's a great trail because they often take a picture of it at your house. You know it's there. If it came from his account, where is the saw now? Why did you buy the saw? Not that he would talk to you. The attorneys probably wouldn't let him talk to you. But that is questions you could bring up that would have to then be answered. The defense would have to have some answer for that. Why did you buy chainsaws? What were you doing with it? Were you cutting down trees in your yard for firewood? A lot of times in a trial, we will see, or in hearings, there are seeds laid down that you may not be able to follow up. You might not be able to prove a point, but you lay that seed out there for people to think about and start to ask themselves, hey, maybe in the jury room, why would he buy chainsaws? She was cut up with a chainsaw. It starts to connect together that, okay, maybe there's no blood on it. Maybe it was really cleaned well. Maybe they missed it. These things happen. They miss it. But I would have certainly tested it further. I would have gone whatever. Like you said earlier, the chainsaw patterns in different things. Well, right there, that's pretty good evidence. If that chainsaw matches the pattern of cutting, then you could say that chainsaw was probably involved. In a lot of burglary cases where there are pry marks and whatnot, most units have entire sets of detectives set up to do that. New Jersey State Police was great for forever. We would call them and they would document the pry marks in the door. They would give us all kinds of specific information that if you finally had a suspect and you got a crowbar, there could be just a little nick in that crowbar that matches what was on the door of the house. That's great evidence. So all of that is important stuff.
Yeah, and I'm wondering, sorry guys, I was eating, I'm kind of in a rush here. The reason why I was wondering this is because I know the defense is attacking. They're looking for any loophole. Obviously, no investigation would like to say is perfect, but obviously it's not the case. There's always going to be some concerns, but a due process error doesn't equate to the fact that the person's automatically innocent and you're going to go ahead and throw away everything else. My thing is I've been learning the word exculpatory. So I'm thinking like if the defense was pushing that, okay, so there was no blood evidence, but you could have further tested to see if he touched this chainsaw at that point. But why? Because ultimately at this point, there wouldn't be enough evidence to go ahead and say that chainsaw was utilized in anything related to the crime. So I thought maybe, even though, like you said, I would have probably saw it and said, you know what, go all out because it's going to be expected to go all out. So if it does come back negative, okay, it comes back negative. I mean, I can't control that, but I would still make the effort. But I also think the argument would be, there just wouldn't be enough forensic value because, like you said, there's not enough blood here or anything on the chainsaw itself. So therefore, if I went and got it tested and he did have his DNA on it, how would I be able to connect David's use of that saw to doing whatever damage it was to Celeste, which would,
right.
in this case, it would be more of the dismemberment.
So what you look at when you create, as an investigator, you create your investigative hypothesis, right? You can't go in just saying, well, we absolutely know it's him. Our job as investigators is not to prove what we think we know. Our job is to identify the truth of an incident, no matter which way it goes, to guilt or to innocence, to find the truth. And here you have, if she was dismembered using a chainsaw, you got a guy buying chainsaws, he's the suspect. Your obligation, from my point of view, is to go all the way. And if it turns out you can report in that, in your report, there was no blood found on it, doesn't mean it wasn't used, doesn't mean it wasn't cleaned really well, but it's a chainsaw and a chainsaw was used. But you show credibility and integrity that we checked everything. We weren't here just to find his evidence on there. We were there to look at the evidence and see what the evidence says to us. If it ends up saying, hey, it's his DNA, that's great for our case. But our job is to seek the truth and find out. And sometimes you have to report. We checked it. We found no sign of blood. Okay, maybe it was cleaned, right? There's a lot of times we get knives. There's no fingerprints on them. People wipe them down. We've all seen the movies. They wipe down the gun. They do stuff. People try and get rid of evidence. Sometimes you can't find the evidence. Doesn't mean it wasn't used. But I think you go all the way in your investigation because that's your job, is to seek the truth, right, not just to prove your investigative hypothesis.
And also, I love what you're saying, because the exhausted effort shows, like, even if they were able to clean it so well, and there's a chance at the end, you feel comfortable knowing that this weapon, at least to the best of your knowledge, wasn't used. Is it 100%? No, but I get a little echo there, Joe.
Is that me?
No, I think it's coming on your side on your speaker. Nothing crazy though.
All right. Let me add something else in there too, Anthony. When you talk about integrity in an investigation, people in a jury, judges, they look at the integrity of the investigation, which they should. Any one of us charged with a crime want to make sure they do it right? They're not trying to shade it one way or another. You just investigate, look for the truth, and you present your case. One of the things that I teach when I teach officers is that when you're up on that stand, everybody expects you to have an answer for everything. You expect you to know everything. And what a lot of people believe in the mind of a lot of civilians, and we've all heard this, is that, well, if they don't know it, they'll test the lie. They'll make it up. Well, there's nothing more powerful than being a police officer testifying if you can not only tell them the facts that lead to the connection to the suspect, but if you could say to them, I don't know. Right. And the smaller the thing you can say, I don't know to, builds more credibility, because people look at that and go, wow, that would have been easy for them to make up. Was it a blue car? I don't remember. Oh, you don't remember? How do you not remember such a big case? Well, I know it was a car. I know it was a Chevy. I know it was this and that, but I don't remember if it was blue or dark green. I don't know. And when people look at that, and I know because I've gotten feedback over the years where people say, wow, if they're not going to lie about something small, then, when they can easily lie and make themselves sound good, why I think that's being honest. I think that's good. So while it might not seem like a huge value at the moment, that credibility and that integrity might help that jury see your point of view later on when you're presenting something else that they have to make a decision on about whether or not they trust you or your answer. They trust you and they trust your answer. That can go a long way to making your case.
Yeah, and then one more question before I get to the next question is do you think does this give the defense something that they can really exploit though?
Yes, absolutely. If you are saying that this victim was dismembered by a chainsaw and you have a chainsaw, it's got no blood on it. That is easy to put in people's minds. People are not forensics experts. Most people that are on juries got picked, they show up, they're on the jury, and they have to evaluate sometimes very technical things, and they don't have any experience whatsoever. It seems very common sense. You're saying she was chopped up by a chainsaw, but the chainsaw you got from the guy that you're charging has no blood on it. If there's no blood, then it wasn't used. So you're just making something up. Or
right. Right. So then, if the defense, I got an echo, Joe. Do you able maybe to? I don't know why I have an echo here. I'll pause it. Sorry about that, guys. So what I'm saying is this: I agree with you. I think that if they noticed there wasn't enough blood evidence, there wouldn't be enough to connect that saw to whatever the crime would have been. In this case, dismemberment. But also, if the defense is also relying on the investigation that is done by the investigator, would they also be able to say, well, you also didn't do enough to weed my client out? You could have also went a little bit further in your testing to see if if he had managed or if he had touched that saw, just in case if anybody else has touched that saw.
100%. The defense is going to throw everything they can against the wall. That's their job, is to zealously protect their client. Now, we all know we've seen cases where you say, how does this attorney not see that this person did this? So they're just making stuff up. You know, if any of us get in trouble, we want an attorney to stand up for us as best as possible. It is on the prosecution side to make the case, to make all the connections. But absolutely, they're going to look for anything they can say. Well, you know, they were just so biased that this was the guy that they went after him. They had this investigative hypothesis from the beginning. You know, the wife is dead. It's always the husband. Usually it's the husband. It's not always the husband. If you go in there with it's absolutely got to be the husband, it's going to change your investigation and your findings. So the defense will absolutely look at that and say, why didn't you check for touch DNA? Oh, because then it would be three things to show that he didn't touch that. And the mind of the average person, they're going to listen to that. And this is where in the courtroom, you know, we have such a picture from TV, how court cases go and how, you know, the good guys usually win out in the end, even if it doesn't look good. The reality is when people go into a trial, every person in there has their own biases, their beliefs, and their experiences about how they dealt with. This is why a good attorney, and this is what separates good attorneys from great attorneys, is that they go in there and they make that case. Okay, listen, we didn't have any blood, but does that mean it wasn't cleaned completely? Matter of fact, we checked and we found out there was some kind of solvent in the house that couldn't be detected 3 months later. It is our belief that that's what happened and it cleaned the saw. Now you kind of fight back on that defense thing going, no blood, couldn't be him. You know, the glove doesn't fit. You must have quit. You know, all this kind of thing. It comes down to the players in the room as well and their credibility. So when you go in, you want to make your case strong. You want to be sure about it. You want to be positive in what you know is absolutely a fact. And then you can make your case for things you believe. And then they have to decide whether they believe you or not. That's why great attorneys can move juries and you say, how could they possibly do that? It's obvious this person is guilty. So it all comes down to credibility in the room.
Yeah, and I think when the credibility gets tested by the defense, I think a big thing is I've kind of learned this in my way as administration. I do issue investigations. I do get tons of investigations coming back, whether they're criminal or administrative. So I've had my hands on hundreds, maybe even more than that by now. The one thing is that the investigative agency is usually going with the presumption of innocence until it can no longer be defended. So they do try to exhaust those options along the way. But at one point, it's just by patterns and other things, it just provides a context where the picture gets a bit murkier and murkier. But I think when you go to establish credibility in a case, that if I'm trusting them to do this investigation and the defense has to lean on the results of that investigation, they're going to want to see an investigation that was fair. They're going to want to see an investigation that showed an exhausted effort to include or exclude. So I don't know if right now, if they're testing the evidence to see if it was tested enough to find some gap, or if later on they're going to argue that the investigation wasn't objective enough, and all you did at this point was look for what could convict him as opposed to what could exclude him.
Right, and that's my bigger point about when you go in there to seek the truth, you have to exhaust those areas. Now, some cases it's easy because you have such obvious evidence. We have witnesses, you have video, you got fingerprints, you got DNA. It's easy to then say, okay, it looks like this is what happened, and now we're going to investigate it. But it would not be the first time that ability to not do more in a case can be a problem. I had a robbery case where a guy, he was doing a shoplifting, and he got caught by security, and he ended up breaking glass out of the window and trying to stab the security guard. And if he hit him with this glass, it was a big piece of that pane glass from the windows, would have cut this guy open, could have potentially killed him. And when we were there, we had all these witnesses that saw what happened, and we interviewed them, we documented them. He was convicted and sentenced to 18 years, I think, in prison. A year and a half.
So we had a little bit of technical difficulty. So it could have been on my end, could have been on Joe's end. But the point is, we were discussing basically investigations on the presumption of innocence.
Yes. Okay. So what I was saying is that absolutely can come into play, because an example, I had a case, a robbery case. Started out as a shoplifting, and the security guard saw the man, tried to stop him. They got into a fight. The plate glass window broke. And the suspect grabbed a huge chunk, like a 2-foot piece of plate glass, razor sharp, and was trying to stab the security guard with it. Now we've changed the whole parameter. Now we have a robbery, an aggravated assault, possession of a weapon, attempted murder, all kinds of things go into a thing like that. And what we found out is he was convicted, sentenced to 18 years. And a year and a half later, I got notice from the prosecutor's office that the appellate division of the court has decided to give him a new trial. And the reason was, he asked, did you interview every single person that was in that lobby, or just the ones that said what you wanted to say? Well, what we did is we screened everybody there. We had 3 or 4 detectives. And when people said, yeah, no, I was here, but I didn't see it. I was over there. I didn't see what happened. I heard a commotion. The people that said I saw it, we took their statement, right? We named these other people that said Mr. Jones was there, but he said he didn't see anything. The defendant says, and his attorney was, well, why didn't you take statements from them too? Because they would have cleared my client. And the appellate division bought it and said, you have to go back and do the trial over. So those things absolutely can matter. So that's why you seek the truth, cover every angle that's reasonable to cover, and then document. Here's my investigation. You know, I did everything I could to find out who did this. My investigation finally led me to the defendant.
Now, I know some stuff may be repetitive. I know you limited time. So I'm going to give some context. If you feel that there's something you can add, please do. If you feel like it's already been discussed, we'll just move to the next question. So the prosecution is trying to show concealment and disposal using the cadaver bag and the burn cage as part of that narrative. He ordered a burn cage, but it was never used. And then the cadaver bag, the body was so decomposed, the cadaver bag was tough to preserve. So I believe they kept the handle on the zipper, but the rest of the bag she was in his frunk, they believe, from the end of July in hot summer LA months all the way till September 8th when they popped the trunk and took her out. So, you know, she was pretty much liquefied. The defense has already argued that the cadaver bag was not fully preserved as evidence and that the burn cage was photographed but not collected or tested. Again, it looked like the burn cage. He could have ordered it, but never opened it. Maybe he had problems, couldn't hook it up, but it was never opened. Suggesting the investigation left potentially important evidence behind. So I don't know. This is just me before I ask the question is, I think that they were looking for evidence that it could have been used when you also should have been looking for evidence of why it was bought. So that would bring it in. So again, when a body is found in a cadaver bag and there's also a burn cage in the home, again, the burn cage was unopened. What usually drives the decision to preserve only some of those items? And how do you explain that to a jury when the defense is saying the evidence should have been collected more completely? Now with the cadaver bag, she was liquefied in a frunk for over a month. I was actually looking at it. Well, wait a second. They still did some testing on the handle of the cadaver bag and the zipper, so it didn't look like they threw it out altogether, even though the defense is making it look like that. And then for the burn cage, they took pictures, but they didn't take it. I mean, does that hurt the case at all?
It can, because it gives the defense something to throw out there. And again, you got jurors sitting there, and the whole idea is it beyond a reasonable doubt. So if the defense can throw some doubt in there, well, why wouldn't they have kept that? Don't you think that would be an important piece of evidence that they would hang on to? I wonder why they threw it away. Maybe because it didn't show what they wanted it to show. So they're allowed to throw those conjectures out there. And, you know, people sometimes they believe.
Oh, wait, but that's interesting, Joe, that you just said that. That's interesting, because if I don't show due diligence in the effort to clear with the same manner I'm doing in an effort to include, then the problem is someone can come and say, well, why didn't you go full route? Why? Because it would have cleared my client.
Right. So documentation of things. Now, some things it's going to be very hard to say. That liquefaction of the victim, that's still the victim, right? So when they took the bag and they removed, this is the remains of a human being. So I don't know what they did in the autopsy or in the forensic examination of it. Sometimes things are just very difficult to maintain. So you video it, you document, then you bring in an expert in preservation to talk about why you could or you couldn't. One of the things that we have to think about going into trial, you have the crime, then you have the investigation, and then you have the trial. These are three separate things altogether. And a smart investigator has got to look at all three of them with the prosecutor and figure out, how do we anticipate what they're going to throw at us so that we can examine that now? Think about what you might be asked on the stand. What might they look for? So if I'm going to throw away a piece of evidence, I better document why I threw that away. There's a bird, and again,
and when you say throw away, you mean not really going, not really handling like you're handling the other evidence.
Right. If they dispose of it, as long as they put it in a hermetically sealed bag, what's left of it, as drippy as it is, but it's in there and it's sealed, it's not a danger, biohazard. There, look, there it is right there. It deformed. It, it came apart over time because of the.
So you're saying the handle on the zipper really wouldn't be. I thought that showed that they tried to make an effort, but
it does. They did what they could, but that doesn't mean the defense can't throw another question. And well, if you save those two things, why didn't you save that? Sometime it might be impossible to save that piece because it's just, it degrades. It's gone. There's nothing you can do with it. But then you cover that. Why didn't we save it, right? Make sure you photograph, document, all that. Interesting enough, as an investigator, and like I'm saying, you need to think, what are they going to ask me about this piece of evidence? What could they possibly ask me? Well, I don't have it anymore. Well, that would probably be a question. Why don't you have it? You better have a very good answer. I remember going to as a detective, I got called to an apartment where there's a bunch of men living in this apartment together. And they were all drinking. They got mad. One guy took a bottle and cut this guy's throat, and there was glass all over the place. And, the ambulance came and the patrol officer was there. Patrol sergeant came, and I'm doing my thing. And he says, you need any help? And I did. There was a lot of people to talk to. I said, do me a favor, have somebody collect up all the pieces of the bottle, put it all together. He goes, what do you need the bottle for? That's a lot to get all that glass. And I said, if that man goes to the hospital and dies, now you have a homicide. Every piece of that glass is part of a murder weapon. collect all the evidence. Better to have too much evidence than to have left something behind that you could say, oh, well, I don't know why, because I didn't think it was important. You know, the minute the defense gets you saying things like that, or I didn't think it would be important. Oh, well, what else didn't you think was important? What did you do? It's to cast reasonable doubt. Many people go to trial as guilty as they can possibly be. And the defense attorney's job is to cast doubt on everything that every single person did to prosecute my client. They were out to get him. They didn't like him. They were incompetent. And you have to anticipate that when you're doing your investigation.
And I like what you said when you connected criminal to investigation or trial, but the foundation is justice. And the investigators are meant to be objective, which means that they're going in it technically with the presumption of innocence. And the prosecutor is the one that would decide the charges. So a lot of people automatically think that the investigators are the ones hungry on those charges. And that's not. They're not even the ones that technically always interpret the evidence. You know, sometimes because I've seen it where my reports come back and basically it's just pretty much, this is what we found. And then the person reading it will determine if there's enough there or any angles that are strong enough, literally strong enough beyond a reasonable doubt to push charges. So usually when it gets to that point where the prosecutor's pushing charges, they're already aware of whatever cracks could affect that.
Right. And those things, I was always a believer that if you have a weakness in your case, and I say this with the caveat that if there's something in your case that you can anticipate the defense would go after and could look bad for you, you find a way to get ahead of that and you bring it out. And you say, listen, this is the one thing that, you know, we can't connect this particular chainsaw to the body because there's no blood. And then you better have a good reason of why. And then you can explain that. And what do you believe happened? Was there another chainsaw that just wasn't on scene? Did somebody take that one away? Right. He bought 3 different ones to see which one he was going to need. And the one he used, he got out of there.
That's the concern, because it's very confusing as to what happened with these chainsaws. I got 4 more questions, Joe. I'm trying to speed through, because I know you have to go too. The prosecution is trying to turn the garage into part of the murder and cleanup story. So basically, after she got dropped off by the Uber, they believe he invited her into the garage, and this is where everything happened. Where he attacked her and then eventually later on decided to figure out ways to dispose her body. While the defense has already attacked fake blood, because there was a fake blood related to probably music videos or stuff that he does. He's a very morbid individual, even his music. Trays, similar prop-like items by pointing out they were documented and screened but not collected. Again, they, even with the blood, well, they discovered it was fake blood. They didn't take it out for further testing. I mean, they're just trying to get him for not checking every possible thing. So when you come across fake blood, trays, or other prop-like items in a garage tied to a murder case, the garage itself, what's the logic behind documenting but not collecting them? And how would you explain that choice so it doesn't look like investigators cherry pick the evidence? I think we discussed that, correct?
We did kind of. And when you look at that, I think there's a little bit I can add to that. Trying to make a decision of what is evidence and what isn't is often done at the moment, in the moment. So you have all fake blood and you're talking about somebody maybe being murdered in a homicide. When you're looking at something.
Right, Joe, through what filter, though, when you say that? So I love that you just said that. So if I'm looking at something that could be evidence, and I don't mean to cut you off, guys. I want to, because Joe, you can always ask anything to who's going to answer it. So maybe just out of curiosity, when you answer it, you could look at everything that's evidence or not, but either way, whatever you're looking to collect or not collect, it has to be balanced by inclusion and exclusion, correct?
Yes. And when I look at this particular example, which is kind of unique, that there would be, fake blood and props of murder around in a place where a murder took place. For me, saying I'm anticipating what's going to come up, that's going to be questioned. I would have documented everything and I would have taken everything. I would have had a room full of stuff. That whole room is, if that's where the crime took place and the dismemberment, that is part of the crime scene. And therefore, I would have, I wouldn't have taken, a hammer on the wall if it wasn't, there was no hammer marks. But I would look at anything that could be construed as blood, body fluid, hairs, fibers, weapons that might have been used. I would have taken it all and tested it all and had an answer for it. Why did I take it or not? Why didn't you take the hammer on the wall? Well, the victim was not, there's no evidence she was beaten to death with a hammer. And we looked at the hammer. It was in the place where it was. We could see dust around. It hasn't been moved in months. That's why we photographed it and left the hammer. But we took the fake blood because fake blood, you could have thrown it on the floor to make it cover up real blood. I don't know. We might have to compare it to something later on that they find out. I would have taken it. Now I have it. Now I can look at it. If I don't need it, I don't need it. But if I do need it and I left it in the garage, they're going to make a case against you that, oh, are you incompetent? Or you just weren't thinking? Or did you not know enough? Should you add another expert in there helping you, planting that seed in the jury going, yeah, why wouldn't they have taken that?
So, right. And this is really fascinating because obviously the crime scene is telling you a story, but until you can figure out exactly what it's telling you, you're going to have to try to collect whatever you can because you have to be objective. And then eventually when the picture starts to narrow, you're able to say, well, you know what, I'll collect it. I still would say collect it. But most likely it's really not taking us where we want to go. Because eventually I think the scene's going to tell you which way you want to go. But in the process, you kind of get directed by also what doesn't count as evidence or what doesn't include somebody. So if you go in strictly saying, I'm only going to get stuff that's going to bury Joe, then you wind up only going towards that direction when I'll give you an example. We're doing the Nolan Wells case, sadly, and I'm kind of going to limit my coverage on that, but everybody seems to be avoiding that he's on an island partying and all these other stuff, a teenager, maybe drinking. It became a race war. It's like, yeah, but you cannot ignore the obvious. And that's why when they come with these independent investigations civilly that are running at the same time a criminal investigation is, how could you say that the criminal investigation is less objective than the civil investigation when the civil investigation is rooted in money?
Right. And the standard is different. Preponderance of the evidence in a civil case as opposed to beyond reasonable doubt in a criminal case. If you think about the Guthrie case, and we see what happened here. Here we have a very high profile, initially, potentially a kidnapping. And you have a high profile woman and you have her mother who's missing. You know this is going to be huge. And if you're going to end up catching someone, this is going to be good. And they left the scene. They had to come back a few days later and take the scene again. And I think they might have come back 3 times. Okay. So and I'm not throwing fault at them because I know there was a lot going on, a lot of different agencies, who's in charge, and that's a real thing. It happens. But while you have that scene, this is where you need to stop and go, okay, let's get a cup of coffee. Let's sit back for a minute. We own the scene. What in here could we possibly need? Why would somebody ask about it? What should we take? And sometimes you make a group decision to leave A and take B and C. And it turns out later on, A is involved. We didn't think of it. It didn't happen at the time. So that's why documenting everything is so important. But a lot of, like in the Guthrie case, why would you have to come back? Because there was things you didn't think of. And now something new came up and we didn't look at that while we were there because we didn't think it mattered. Right? When you're talking about something very serious like that, you have to consider every single possibility and deal with it. The
only thing I would have liked for that, and I've been lowering my coverage on that, is I think they should have held the crime scene a little bit longer, knowing that you may have to go back eventually. And then I have 2 more questions, Joe, that I want to get to you. We didn't cover everything, but I think that you were able to answer so much that would cover something. Some of, like, I wanted to talk about digital evidence, the vehicle, the cell phones, but right now I have 2 other important questions. Of course, you're limited on time. I really got to get these 2 questions out. One is Steve Fisher. He's a private investigator for the people that own the house where it happened. And then somehow or another, he became the spokesperson for this case, trying to say he's the voice for Celeste, which he's not. He's got his own motive. He's hired by the person who owns his house, who's probably trying to protect his own liability. My biggest thing is if you're in law enforcement and you're conducting an investigation, because the prosecution side, Beth Silverman, is very pissed off at him. He doesn't want him. She doesn't want him there at these prelims because he's also a possible witness for the grand jury. He was a witness for the grand jury, so he may be a witness later on if this ever goes to trial. So she doesn't really want him talking to the family of Celeste Rivas Hernandez. I mean, I don't trust the guy to begin with. I at first I thought he was okay, but then I just really started to see something different. do PIs, private investigators, at the same time you're running a criminal investigation. So you got your investigation and whatever motive they got because they're hired. And I think, of course, that they're hired, in this case by the homeowner. He's not going to be objective. He's going to do whatever he can to help the homeowner from liability. Do they ever conflict with when you have those two investigations running at the same time and you're trying to secure something, maintain integrity, and this guy's going behind the scenes, going on national news, exploiting all the work you're doing to the point where you may have to bring this to a grand jury and start putting security holds on, let's say, releases of autopsies and stuff like that, because you got people going behind your back.
Absolutely. It absolutely complicates a criminal investigation when you have someone other than the people who are charged with conducting the investigation, the criminal investigation, the law enforcement people. These private eyes, they can get hired. And you're right, there's different motivations that they come in, and they're going to go try and look and prove what their client wants them to prove. Doesn't mean they're going to lie about it or manufacture evidence. Just means they're there to look for the interests of that client. And if that is, A, B, or C, they're going to look for it. They start talking to people. Right now, they start leaking what somebody might have said. That could certainly affect other witnesses. And I have had it where, and I got to say, I've been very, very happy in the course of the incidents. When there was a private investigator involved, most of them reached out to me and said, hey, this is what I'm doing. Can I help you in any way? Or I'm going to talk to this person. And I would say, please stay out of it. You can have access to a lot of stuff later on, but stay out. And they've been pretty good about it.
Can you get them for obstruction?
If it depends on what they do. If they're obstructing your investigation in some absolute tangible way, where they go in and they start talking to witnesses saying, hey, don't talk to the cops, talk to me, because the cops don't like you in this, and you can find that out. Now they're absolutely obstructing me. If they have evidence or they know of evidence and they manipulate it so that they have it for their case, now they're tampering with evidence. There's lots that can go.
Oh, so they have to. So that's a good question, because this is something he pulls out. That's why I love having you on. So if he is saying he works for the owner of the building and basically his loyalties to the owner, and then the prosecution says, yo, you're finding out these things, you really shouldn't be talking to anybody, especially after you've been to the grand jury, even though you're a witness. I know there's the laws really relate to the juror, but with that said, you're continuing to find evidence, and then before you give it to where it's got to go, you go to your client first, and that could be a concern with due process. But can you hold them liable for that?
Well, again, everything, the word depends. I hate that word, but it's true. Depends on the prosecutor, depends on what the evidence was. If they find evidence that involves the crime and they secure it, they keep it themselves, they show it to others, now they are tampering with evidence, right? Just because they're private, they're an individual that has a license to ask questions, to try and put together a case, not a criminal case. So if they find, hey, I found the murder weapon at the edge of the woods that the cops didn't find, I'm going to take that, I'm going to do something with it. You're now tampering with evidence. That's tantamount to the defendant coming back and going, gee, I dumped the gun over. Hey, it's still there. Let me go take it and throw it in the lake now. Okay, nobody's around. The cops didn't find it. You just tampered with evidence. So there's potential that they could be held with that.
Right. And since he put himself as a PI in some level of evidence collecting, whatever he winds up turning in his blood is muddy anyway.
Yes, it's been.
We have no idea what he did with it.
Right. So you can certainly, we can make that case about police officers. If you have an officer making a ridiculous statement on social media, and then they're investigating a crime, that could come up and go, what's the credibility of this cop? Well, now you got a guy that's getting paid to protect somebody, got the evidence. Did he wipe it down? Did he clean it? Did he throw some of it away? It becomes a natural connection to what's this person doing? They're obviously trying to manipulate the case in one way or another, and that damages evidence and could change the outcome of a case.
And the biggest concern you have too is he's connected to the homeowner. Who knows if he's not talking to the management team of D4vd? And I know you got to go. I did have one more question. And this is, to me, important question. So a lot of people think that the prelim here is a little bit of an exhausted measure when well, they're putting a little bit more than they should because it's only reasonable doubt, so 51%. But I also think Russ made a point that, just get the 51%, be done with it, and let's get this over to trial. And I understood that, but I also think in the process of what they're doing with this prelim is they're going for the first-degree murder charges. They're going for the sexual assault or lewd acts with a minor under 13, and then also the mutilation of a body. But there are some special circumstances that they want to connect to a possible death penalty sentence, which is lying in wait because supposedly, it's in the records that she basically threatened him, like basically, basically if there's a breakup, whatever here, I'm going to ruin you. I'm going to turn you in. There's a noted text that showcased that she was a victim, but she also had leverage on him that she could ultimately turn him in and he could lose his career, go to jail. So the special circumstances they had was lying in wait. Pretty much he called for the Uber to have her come there, and that's what they believe it happened immediately, probably in the garage, because I think there's some text that they may find out about him saying the garage is open, come in, and they believe it happened almost immediately. They have the killing of a witness because she was a victim, but she's also the witness to what happened to her. And then they have the financial gain because he was going to have a successful music career. I'm sure he knew about that. And when she made that threat and could have exposed him, at that point, he made an effort to protect themselves. And then me and Russ were having the discussion that maybe this effort is going a little bit longer than it should because they're trying to prove special circumstances because the judge will ultimately make a decision as to what can go forward and what can't. How hard is it? Because now you're looking at motive, which usually is not something you need, but in this case, they really want, including financial gain. The fact that she could have turned him in, he could have lost everything because he was getting ready to do a tour the next day. So you have the pressure of time where he couldn't really make a resolution with her, and she would have exploited him because she was underage. She was 14 at the time of her murder, and he had sexually exploited her since she was 13. Then you got the killing of a witness, which I think is automatic if you get the one circumstance, and then the lying in wait, at least from the fact that you ordered an Uber and then you paid for the Uber, and then she arrives there, and within seconds, most likely, you killed her. How hard is it to prove special circumstances, and do you think that is needed right now at the you think it is good to do an exhausted effort right now at the prelim to try to make sure that you can introduce those three special circumstances, the lying in wait within the context I mentioned, the killing of a witness because she was sexually assaulted by him and she had leverage of what he had did to her, which could have jeopardized his career, and then the financial gain because he would have benefited from her career.
Right. So if we think about the three buckets that I laid out before, the crime, the investigation, and then the trial, what preliminary is normally to, move forward to the trial, to lay out your case so that the judge can say there's probable cause to move forward, that the crime was committed and this person committed it. So that is often used to just lay that stuff out. When we do it more serious like this, it could be to show, hey, I'm showing my hands. This is where we're going. Look at the strength of the evidence that we have, that it looks like we're going for the death penalty. We very well might get it, which can induce the defense team and the defendant to say, listen, let's make a deal because they looks like they got you pretty good. I mean, maybe we can beat it, but if we don't, you're going death penalty, as opposed to jumping in now. Look at the strength of the case they have. And those three things you pointed out are extremely reasonable, and anyone can understand the motivation to commit such a crime when you have such very high value things that could be a problem for you as the defendant. You're ruining your career. That's worth millions of dollars. That's a motivation alone. People kill people because they want a bottle of soda, not because they're going to destroy their multi-million-dollar career. Getting rid of that witness. Why do people in a robbery? I robbed the drugstore. Why do I shoot the clerk? So that there's nobody to point to me later on and say, hey, that's the guy that did it, right? So that's an absolute understandable motivation. and getting rid of that witness and so that she can't turn around and testify, absolutely legitimate.
What about the lying in wait?
Absolutely lying in wait. I mean, that goes to presence of mind to do something criminal. I wanted to get her in here so I could get her.
Right. The moment she made the threat on a documented text, and then he calls for the Uber, and most likely she died. It was April 23rd, 2025. She died, they believe, within minutes of her going there, because then he starts to scramble, and there's no cell phone, there's no activity on her phone at that point. So they do believe it's within that moment.
Sure.
But the lying in wait. So here, I'm sorry, Joe, you're so good. One last question, I'm done. I know the defense is trying to push, and bear with me, guys, because it's a thought that's got to come out. So hear with me, because I'm trying to explain it, because Joe's not too familiar with the case, but he learned very quick. When he had the pressure of time, knowing that they're going to they have to leave, he's going to start his tour. Once she said, "I'm going to turn you in," there was no chance for a resolution at that point. That would take time. He had the pressure of time. He had to commit to something. So I do believe that he invited her over in an effort not to work things out, but just, I'm done with this back and forth. I can't risk it, because once I start this tour, I can't have this leverage over me. So again, if you can prove it, I don't know. But then afterwards, I think because of the pressure of time, he didn't plan what to do with her body afterwards. And that's why you see sloppiness in the multiple ways he tried to dispose of the body, which we don't have to go into too much detail. He'll just know that the car winded up in his trunk months after, because he still couldn't get rid of the body. And I think the biggest concern about that is the body wasn't just the concern. He had evidence in the car, so I think he wanted to get rid of the car and the body. I think he would want to have done both. But a lot of people are going to try to look at his cleanup and say, well, it was impulsive, and try to connect that to the murder, saying, of course, it wasn't planned, because he didn't know what to do after he killed her. Two separate acts.
Two completely separate acts. Lots of people, most people that we deal with, even the ones that commit horrific crimes, they are not criminal masterminds. They have an idea, they have pressure, they feel all these internal, they have to do something. The prosecution would lay out their investigative hypothesis based on the evidence they have. The girl got there. She ended up getting murdered. How do you chop up a body? Anybody out there actually chop up a body? I mean, we see it on The Sopranos. It seems pretty easy. You go to the meat store and you chop them up. Do you have access to those kind of saws? Do you have where are you going to take a body? What if you get pulled over for running a red light and you got a body? It's not as easy as people think it is, as TV might make it out. So it would be, the murder is, okay, I got to kill this person, and don't necessarily think about the second part. Maybe he thought, I just kill her, I'll put her in the bag, and I'll take her somewhere and dump her. And then he had the idea, maybe she didn't fit the way he wanted. It wouldn't fit in the car the right way. Something's, all right, what I'll do, I'll chop up the body, right? People think that. In my book, The Investigation, right? Brutal double homicide, I go through it. This guy killed his baby mama and his grandmother, and to try and fit what he thought was going to be, if he got caught or got in trouble, that it would be a mafia hit, he cut their head, hands, and their feet off, right? Because that's what mafia people do. And that was along the line of that was our hypothesis. Why else would you do that? But it fit with and we laid that out. And, obviously that's what I believe happened here. But the reality is that motivation afterwards is completely different sometimes. People are not criminal masterminds. They don't have a place where they can chop up bodies. Now they got a body. You have a human being. What are you going to do with it? And if you've never cut up a human being, it's physically, you're cutting somebody's body parts apart. That's going to be very difficult to do for the average person. Now you add to that anxiety, upsetness, time. I got to get out of here. That can lead to, well, what do I do now? Right. And that's where we catch a lot of people, because they're not criminal masterminds.
Oh, perfect. And Joe, do you have anything you'd like to say? I know you had to go. I had one last question about digital evidence, but I don't know. You have to go, correct?
I do. I do have a hard stop, but let me just throw it in there about evidence. Digital evidence is great because it's got a footprint. Cameras, emails, texts. All those things have, what did they say? Something on the internet never goes away. Well, for all you people out there Googling things you shouldn't Google on different databases, those things you might hit, erase my history. That's not erased. That stuff is still around. So digital is a whole nother realm of evidence that we can find. They can ping towers. Where were you calling from? We have every house has Ring cameras now. You know how many crimes are solved by Ring cameras now? Because it is digital evidence. And we can find timelines of where people were by where they pinged. Well, I was never there, but they can ping and say you were in that neighborhood.
So you're hitting it spot on. The question was, the prosecution is using phones, texts, and cloud data to connect Burke to Celeste and to the broader timeline, because there's also child sexual abuse material on the phone. They have proof of ownership of the phone. Then also the phone connected with his Tesla, the digital evidence that shows him moving in alignment, but they have to show him that he had the phone, he was in the car. The defense has already challenged whether a light blue iPhone and related iCloud or email references were clearly tied to Burke rather than Celeste, which makes device ownership an important issue. And it says when multiple people are associated with one device or cloud account, what's the right way to document which phone belongs to whom? How damaging is it if the defense can make ownership look ambiguous? Or, we see the Tesla connected to his email account moving with his phone, which should be his phone. But if you really don't have him in the car with the phone, people could say, well, he didn't have his phone. So, maybe how do you know that's him? Because it's his phone. Not enough.
Right. But what it does, and when you see a good attorney in a complicated case, no matter what it is, and they start to lay out their case, you can sit there and say, what is with the minutia here? Let's get to the meat and potatoes of what we're doing. And good attorney is going to lay out layer after layer after layer, so that way you might not have a smoking gun, but I have just set up so many layers that point to this person that initially you might say, well, it's not 51%, it's 49. But when you put all of those factors together and then you make your case, that can push it over into, yes, there's probable cause to believe this person did it. And even in the trial, the jury sits there and listens to all of that, and they keep seeing thing after, okay, maybe he didn't have his phone in his car. Well, then the defense is going to have to answer somebody. They're not going to put him on the stand. Who had his phone? Who might have had his phone?
Does the defense have to prove that, though?
No, they don't. Defense doesn't have to prove anything. The prosecution has to prove everything. But that doesn't mean you can't ask the question, plant that seed in the jury's mind. And now that, defense, well, we have to find some way to explain how come you didn't have your phone. Well, who had the phone? Subpoena that person. I didn't have his phone. I don't know why he's trying to get me involved in this. I didn't have his phone. My point is that the layering of a trial, and that's why there's 3 buckets, the strategy of a trial, the details of a trial can be extremely complicated, but good attorneys will put all this stuff in layers so that at the end of hearing the evidence, whoever hears it ends up coming to the conclusion, well, there's no blood on the chainsaw, but everything points to that guy. I think that guy did it.
So it's funny, Joe. Sorry, man. The defense, I know, can't lie, but they do create stories that imply. So, like, it wouldn't be like they're not going to say David didn't have the phone. They're going to say, prove me David had the phone.
Right. They don't have to. Yeah, exactly. When you are prosecuted, you have no obligation to prove anything. It's the prosecutor has to prove everything against you. So therefore, they lay out their case, and sometimes they lay out speculation. They bring in a witness to talk about it, an expert to talk about, how often phones are left in people's property that they forget. I'm facetious about that, but you find someone who studies that and say, 99% of the time people have their phones on them because we know that because of this. So now you're set up that it's only 1% of the time that this person wouldn't have their phone. And in the meantime, we show his phone records. He was talking to his mother. He was talking to his sister. He was talking to 3 other people, business people.
Right.
Somewhere in the middle there, this girl got murdered. And that's the moment he didn't have his phone. And that closes the gap in people's minds. Well,
and the lawyer, his defense lawyer would probably know he had the phone, but she's not lying. She's just saying you got to prove he had the phone. Someone else said, well, you know, defense lawyers, they lie. I don't know so much if they lie because they could be removed, but I think that they force you where you have to prove it. So like my client told me he had the phone, right? But that doesn't mean that I'm going to go in court and say my client had the phone and give him that.
Right, because that proves that's a crucial piece of evidence for the prosecutor. Might say, yeah, that phone number is registered to my client. He says he didn't have the phone. That's all they got to say.
And you said he said.
Yeah.
So let me ask, man, if the prosecutor comes out and is able through the discovery to kind of showcase that this stuff belonged to him, because I think obviously this is reasonable doubt. I think they have more things that connect them. I just think they're not showing it. They don't have to. It's only 51%. Right. But if there is something there, I think it gets to a point where the lawyer says, listen, outright lying for you, I can't do anything here.
Yeah, no, they can't. But let's look real quick, and let me just throw this out there. Recently, we saw the preliminary hearing for the Charlie Kirk murder.
Right.
And all they had, they got a guy with a gun. They got comments that he made to people. They got emails. They got visualization of people identified him. It's 51% that it was him. Now go to trial and prove your case. They were much more in depth with what they were laying out to show that defense team, we are showing you this 10% of our case, and that 10%'s got you buried. Wait till you see what's going to come. Maybe that makes a difference in their minds to go, maybe we should make a plea here and come to an end with this, because if not, you're going to get the death penalty. Those are absolutely decisions that have to be made in some of these cases. It's very, very rare that somebody who didn't do it is going to be charged with it and go to trial.
Yeah, I agree with that. And I told Russ, I think the reason why it's kind of, they're putting a little bit more than we usually put is because they want to go for the special circumstances, which requires a little bit more effort.
100%. They're laying that out there so that the groundwork is out there for those special circumstances. The defense then sees it. They realize where this might go. Hey, it's one thing if we lose, you get 10 years. If we win, you get off. They might put you to death if they get you here. And the evidence looks like you did it. You know what I mean? There's no other. It's like OJ searching golf courses for the murderer. It was obvious what happened with that. And that was in that third bucket, that trial bucket, that court bucket is what people don't always understand, how that system works. We think it's truth, tell the whole truth, nothing but the truth. This is all we're going to do. The court system is set up so the defense can make the best possible case they can for you and lay reasonable doubt. And to that end, anything pretty much goes. You'd be surprised. This last story I can tell you is that I've been in trials where I knew the defendant. I had arrested him multiple times before for similar kind of crimes, and he was not going to take the stand. So I can't bring up his previous history. Guy's a burglar, and I caught him in another burglary.
Yeah.
Well, I can't bring that up unless he testifies. Then I can ask.
But doesn't the special circumstance maybe allow for some of that pattern? Like if I, in this case here, well, you got the murder charge, but you also got the child sexual abuse. So you have two things connecting at once. Well, you have three charges because then you got the lewd act, you got the murder, then you got the mutilating of a body. But they all connect to each other. So in that case, you're going to have to use, because I think they were going to try to say, you know what, you can't use the child sexual abuse material because that will make it biased for the murder.
Right.
But you need it.
But if it's part of the case, then they have to bring it out.
How do you make that? What would be the one thing that would make that determination that this isn't biased, that this is a direct cause? Right. That's the special circumstance, right?
Right. If they charged him with the child's abuse material, if that's one of the charges he's dealing with, then that's going to be part of the whole case. You can make your argument very clearly that, look at what happened here. This girl is dead. Why is she dead? Because he was abusing her sexually. We have videos of that. We have this, that. We have all this stuff to show he did that. And then she came forward and said, I'm going to tell on you. Well, that's one of the biggest things.
That's what connects it, right? So there's no way a defense lawyer could say you can't use it. No, you could, because Celeste's last text or words from beyond the grave connected it.
Yes. And I think that's the case that they would make. This is all connected together. She said, I'm going to tell on you. And he decided, well, I can't get in trouble. I can't lose my business. I'm going to wait for her. I'm going to get her tonight. And you attack her. And then lay out witnesses and evidence for the jury to go, yeah, that's what happened.
Joe, that is so powerful, Joe, because originally they were trying to, I think, do something where you couldn't connect the two. So not only does that connect to the special circumstance, but you're right. It also connects to the fact that you can't isolate these two because one is a direct action of the other, and you can't pull some bullshit that one's going to bias the other and find me guilty. And Joe, if you went on a crime scene, you opened up a frunk, and the first thing you see is a decomposed 14-year-old girl, the first thing that comes in your mind is your own children, right?
Yeah, absolutely. You can't help but do that as a person in law enforcement. When you see kids, you can't help but, if you have kids, to say, this could have been my kid, and you look at that. And just off of that, you say a 14-year-old girl chopped up in the trunk of a car. Your natural inclination would be, it has some kind of a sexual component here, because who just chops up 14-year-old girls?
Right.
14-year-old girls get kidnapped, they get trafficked, they get raped, they get tied up in basements and used as sex slaves. That would be one of your first thoughts. Who is this? And why is she in this trunk chopped up? And what happened to her to lead here?
Wow. Joe, anything you want to say in closing? Thank you for giving me the extra 20 minutes. I would love to have you on again. I just don't know what's going to happen on today's recap, but there's something I feel we could explore, including the medical examiner's office, because I would love to maybe reach out to you one more time before I go to New Hampshire to discuss basically, if you don't have a murder weapon and you have a decomposed body, which we're thinking this is what happened, what do you need to now secure the conviction?
Right. You can certainly call me and before you go. And if I didn't go on my trip, we can come back and talk about it some more.
Yeah. I love it. All right, Joe. And thanks for coming on. And guys, if we get a chance, he promoted the book. Check out his podcast. What's your podcast, Joe?
All right. So the podcast is the Blue Heart Webcast. We're on YouTube, youtube.com/@Blue Heart Webcast, where I talk about all things police. I talk about cases. I talk about evidence, techniques, training, what happens and why. And the book, The Investigation, is available on Amazon or through blue360media.com. You can get that. It teaches you how to do an investigation, but I do it uniquely. I tell the story of this brutal double homicide, and then I go back and teach each part of it so that you can figure out. So if you're a true crime person, this can be essential to you to figuring out when you're hearing stories, you kind of have an inside scoop on what's going on in an investigation.
I love it, Joe. Love having you, Joe.
I love being here.
Yeah, as always, guys, stay safe. If you guys like the content, buy me a cup of coffee. Link that's in the description as well as top of the YouTube channel. Stay safe.